And go ahead. Thank you. Go ahead, Maddie.
All right, I'll take it away. Thanks, Marcia. As Marcia said, I'm Maddie Bell. I'm an associate attorney here at Cavitch, and I'm joined by my colleague, Matt Stain, who's a partner here at Cavitch, and we do a lot of employment litigation and counseling for our clients. Today, we're going to be talking about race and national origin discrimination in the workplace. And I think that race discrimination and national origin discrimination is a little interesting in that it paves the way for a lot of other frameworks of discrimination. More recently, we've seen sexual orientation and gender identity be added to the list of protected categories under Title VII, and a lot of that analysis stems from the original analysis of race discrimination. I know that some of you on the call have probably seen the presentations that we did on sex discrimination as well as disability discrimination. So I'm just going to walk through the risks of discrimination in the workplace just briefly, but I do think that it is important to go through again. So when you're looking at race and national origin discrimination, if you're discriminating, there's going to be a loss of talent. You're going to lose talent, current employees, and you're not going to get additional talent. You're going to miss out on talent that's in the workplace because of discrimination. And that leads to a lack of diversity. There's a lot of studies that suggest that a diverse workplace is a more productive workplace, a more creative workplace. And in today's world, it's definitely a miss on your part if you're missing out on that diverse talent. And there's going to be a risk to your operations. So, every day when you go to work, when your employees go to work, you want them to be productive. That drives revenue for the company. And if you have a culture of discrimination that's occurring, that's going to disrupt productivity and create strained working relationships. You're going to have a strain between individuals that are involved in a potential issue of discrimination. You're also just going to have a strained culture. Today, with the use of social media and just how easy it is for employees to communicate with one another, those types of issues spread quickly amongst employees, and it's easy for them to communicate about them in real time. So it's definitely going to be a risk of operations if there's race and national origin discrimination issues in the workplace. And if those types of issues aren't dealt with quickly, you can have litigation that arises. Just like in our other presentations, the risk of litigation with regard to race and national origin discrimination is costly. It eats up your time, it eats up your employees' time, and that goes back to productivity. And it eats up money, company resources that you could be spending on new equipment. You could be spending hiring additional employees. You could be spending on training. You don't want to spend your money on litigation. And reputational risk. Just like I said, employees are able to communicate with each other in real time about the issues they're experiencing, and they can make those issues public on social media pretty quickly. So these are just a few of the risks that we wanted to point out with regard to race and national origin discrimination issues in the workplace.
Maddie, I was just going to jump in and say, obviously, as lawyers, we're in the counseling business, and counseling regarding risk, we're not here to tell you that if you run a great shop, you'll never get sued.
Right.
It happens.
Right.
And I'd be blunt about it. When people get fired for performance reasons,
right,
it's the rare person who walks out the door and says, you know what, that was my fault.
Right.
Oftentimes, people will think about likelihood, or at least the possibility, that they were in fact mistreated. And one of the ways to avoid the risk of that turning into an expensive and potentially very expensive litigation is to kind of follow the path that Maddie was just describing. On the upside, and I agree with everything Maddie was sharing, I mean, in counseling businesses, and I don't know that people need to hear this from their lawyer, but I think it's absolutely true, and we see it on a daily basis. Real diversity opens up real opportunity. It opens up markets. It helps a business be more successful. And a commitment to diversity actually tangibly helps a business, most obviously, by providing you with a broader talent pool.
Right.
If you're looking for the best people, irrespective of where they're coming from or who they look, what they look like, or et cetera, you're looking at a broader talent pool. So it's both upside and obviously minimizing downside.
And the diversity of experience that these individuals bring can only help your business. They're coming from different places in life. They grew up differently. All of this is going to create a lot more creative work environment and drive revenue for your company. So, okay, so the risks of workplace race and national origin discrimination issues, what's the law on these things? Where does it say that employers can't discriminate based on these protected characteristics? Max is going to go into a little bit with regard to Title VII in Ohio's Revised Code 4112, similar to our presentation on sex discrimination. Both of these statutes protect race and national origin and color, actually. So I'll let Max talk a little bit about the protections under the law.
Just briefly and historically, obviously, race discrimination rooted in slavery is our original sin. It's a founding part of our history, and battling that is integral to how we govern, how we organize our public places, how we think about our workplaces, and how we live together. And I say that to kind of jump into the topic of race discrimination with respect to the law. Going back to the Civil War, the original anti-discrimination statutes were drafted in conjunction with the new constitutional amendments, the 13th, the 14th, and the 15th Amendment, was a federal law which prohibited discrimination on the basis of color. And that's still an actively used law today. Section 1981 or 1983 are both still very much alive and with us today, which prohibit certain discrimination, including work discrimination, on the basis of race. And going into the kind of the latter period of the civil rights movement in the early 1960s, the United States our government passed Title VII. And Title VII, again, broadly prohibits discrimination in a number of areas, particularly and specifically, as we're talking about today, the workplace. Title VII says, "Thou shalt not discriminate against men or women on the basis of the color of their skin." It's a broad and fairly simple edict, but it obviously gives rise to a very complex set of policies and outcomes. Most states, in fact, I think all states, have also passed parallel statutes, which similarly outlaw discrimination based on race. In Ohio, that statute is the Ohio Revised Code, Section 4112. There are other sections within the Ohio Revised Code that similarly prohibit or also prohibit discrimination. And to be clear, we're not just talking about color discrimination, but we're talking about discrimination on the basis of where your family's from, what the color of your skin may be, or even what your religion may be. But that's the topic today, is that particular kind of brand, let's say, of discrimination and the consequences that can arise from it. So Maddie's kind of set out a nice outline here in terms of the types of discrimination that we don't allow in the American workplace: race, color, national origin, religion, age, disability, sex and gender, and now more recently, sexual orientation or gender identity. It's helpful, I think we may have touched on it in an earlier lecture, but it's helpful to kind of think about also what this means from a legal perspective in a procedural context. If an employee believes that they have suffered workplace discrimination, under Ohio law and federal law, the employee is compelled, before they bring a lawsuit, to first bring what we call an administrative action. So they'll file essentially a complaint with either the Equal Employment Opportunity Commission, which was established with the passage of the 1960, I think, 3 Civil Rights Act, or they will bring something with the Ohio Civil Rights Commission. They're parallel organizations and their processes are very similar. Again, an employee who believes that they've suffered discrimination before they can bring a lawsuit has to bring an action with those 2 organizations. And those organizations will typically focus on 2 things. First of all, an initial determination as to whether something illegal has happened. And then second, some attempt at bringing the 2 sides together, either by remediating whatever the issue might be in the workplace, or sometimes a financial, a settlement where the person who was going to bring the action says, okay, I'll go away for $5,000. That's a very typical outcome at either one of those commissions.
I'll just jump in quick too to say that the mediation process through the Ocrc and Eeoc, if you feel that there's some exposure for your company, if there's a charge, and you're willing to settle for a specific amount, that's a really good place to start. You get to kind of hear a little bit about the opposing side's case, what they think their strengths are, what they think maybe some weaknesses are, as well as you get to evaluate your case fully. And if you are going through that process, that mediation process is a free process that these agencies offer. When you get a little bit further down in litigation, if they file a lawsuit, you would be looking at mediation either through the court, which is a free process, or through a private mediator. I think that Max and I tend to like private mediation because these folks are practicing attorneys. A lot of times they're former judges, and they're really going to give you a good sense of, the strengths and weaknesses of your case. This is somebody that was likely on the bench for, some time. How would it come down in their courtroom? What do they think about the case? But this is a really good starting place. If you can get it done early through a free process, you might as well. And there's really no downside to hearing what the other side has to say.
Well, there's one, I'm just going to qualify that in this sense. You can't engage the mediation process if you're not coming there with the intention and the willingness to compromise.
Correct.
And that is, a lot of instances, an employer gets a letter from the Ohio Civil Rights Commission and it says, this guy you terminated, and he says you terminated him because of his background, for an illegal reason. And you know darn well why you terminated the guy. The guy did something that was clearly and unequivocally wrong. He did it. And there's no question either in your mind or in the mind of a reasonable third person that that's why you did it. Well, I'm not mediating anything.
Right.
And at that point, what you'll do is just probably engage the process, write a position statement, and then if they bring a lawsuit, they bring a lawsuit. I like the mediation process for one other kind of strategic reason, and that's whether a lawsuit's been filed or you're just early on in the Ohio Civil Rights Commission or wherever you are. It gives you a free peek at how this individual views their case. And it's best if they brought their lawyer, and that'll be more often in a court, because it's going to give you a free peek of how the lawyer views his case and the pitch that the lawyer gives both you and the mediator in terms of why you ought to resolve it. So you're going to understand better the kind of salient points that they believe create liability for you. And strategically, kind of like getting in the other team's huddle for a minute, I think it can be helpful.
Yeah, I agree 100%. It allows you to really take a look at your case as well. And sometimes for us, it has to do with client management a little bit.
Absolutely.
Having the employer understand the risks. You say you want to fight this thing, you want to go to trial. Well, what does that really look like for you, money-wise, time-wise, and what is the likelihood of success, and what's your potential exposure? So I'm a big mediation fan.
A good mediator, when it's appropriate, is there in order to help both sides understand the risks that they face. And in the end, when we settle litigation matters, that's really what we're doing. We're buying and selling risk.
Right.
Obviously, there are times when there's emotion involved. There can be a lot of emotion involved. Are you calling me a racist? are you telling me that I'm incompetent?
Right.
You know, these are highly, you know, personalized, you know, confrontational type of issues. But still, in the end, you're buying and selling risk, at least at some level.
I think it's also important to note, you know, Title VII and Ohio statute, they protect folks from discrimination regarding immutable characteristics. So Max, do you want to describe a little bit about the case law behind what's a mutable characteristic versus immutable?
So mutable, or let's start with immutable. An immutable characteristic, and I don't mean that people probably know, but for me, I had to make sure I was firmly grounded in this as a lawyer. An immutable characteristic is that which I cannot change. I cannot change my heritage. I cannot change. Recently, we've determined that I cannot change my sexual orientation. I cannot change my gender, etc. It is generally illegal to discriminate against me for an immutable characteristic. A mutable characteristic obviously means something that I can change. You may have a dress code that says I can't wear my hair over my collar if I'm a male. Generally, that being a mutable characteristic and generally non-discriminatory in its application is permissible, although I'll tell you dress code stuff gets litigated all the time. But nevertheless, that's a mutable characteristic, meaning you can change it, get a haircut. Immutable characteristic is that I have African hair, and that is not going to change irrespective of what I might do or undertake.
And I think with regard to grooming policies, it's also important to note, you know, right now we're in a really tough place with regard to hiring. A lot of the employers that we represent, you know, they're hiring constantly. They can't get enough people. So, you know, if you have grooming policies, take a look at them. Are you still following them, or do they need some revision? One of the things that I've seen most recently in a couple of employee handbooks that I've done, employers are a little bit more lax with regard to tattoos in the workplace. Both of the recent handbooks that I did were for warehousing and manufacturing clients, and they said, we don't care about that, take that out, we don't need that. Whereas maybe a CPA firm or a law firm feels a little bit differently about that. So take a look at your grooming policies and see, do they accurately reflect your workplace? Do they accurately reflect the type of people you're trying to attract?
But Maddie, let me ask you this. I mean, if I'm an applicant for a job, customer-facing job in a bank, and I've got a tattoo of some satanic figure on my hand.
Yeah. No.
Are you able to tell me that, look, I can't live with that?
Sure. Yeah. Especially in client-facing positions, like I said, there are just some industries that, you know, don't want to have that type of appearance in the workplace. Tattoos being one specifically. I've seen a lot of pushback with that with regard to accounting firms as well as law firms. And, you know, if it's like you don't like the message or the tattoo is, you know, somewhat disturbing, perhaps even in a manufacturing company, it's just not going to be appropriate. It's not going to be something that they can live with. And yes, you can, as long as you're applying that uniformly. So if you have a white person with a satanic tattoo, you're not going to make a exception for them. And if you have a black person with a satanic tattoo, you're not going to make a exception for them. So as long as the grooming policies are applied uniformly, you're going to be okay.
I can tell you, as federal courts and state courts too kind of struggle with this issue of, you know, is this a legit grooming requirement or whatever the requirement may be? It may not be related to grooming. The question is, does this employer have this rule as if we take a real look at this rule and the evidence that maybe a plaintiff has presented, is this rule a proxy for discrimination? That's going to be the question. They say that, you know, they don't want you to have your hair a certain way, but it turns out they only apply it to people with African hairstyles, or they say that, you know, whatever, that's an obvious example. Is it a proxy for illegal discrimination? And one of the kind of signal sort of tells as far as that goes is, do people apply these things consistently? And I can't, the word consistent, and I don't want to go off on a tangent, but if there's one problem that we consistently run into as we counsel and defend employers in litigation, it's inconsistent application of workplace rules. It is inconsistent undertaking of employee evaluation. It is inconsistent application of discipline, of salary perspectives, et cetera. Consistency is a word that comes up a lot in our world.
As well as inconsistency in documentation. I had a case recently where, it's a very sophisticated company. They have formal written ADA policies and papers that are normally given to the employee, and one employee just kind of fell through the cracks, and that inconsistency in the documentation of this ADA accommodation, and this can happen with, a race discrimination issue too, a reporting or, some sort of investigation. If it's not documented properly, that can open you up to exposure that you otherwise wouldn't have. I was completely comfortable with this client's position, and it was an Ocrc charge in this charge, until I realized that they didn't have consistent documentation with regard to this person. So it's a huge problem. We had to settle that case because of it.
And Maddie, you would agree, that is a good client,
Oh, yeah.
a good person,
a good employer,
operating an honorable business.
Correct.
Who wouldn't discriminate against anybody.
Correct.
But they made mistakes with respect to administering their business.
Correct.
That gave rise to potentially credible arguments that a bad person plaintiff brought.
Correct.
Just an example of how that can happen.
Right. Yep. All right. So Max went through a little bit of the legal process with regard to the administrative process, but do you want to kind of walk them through, what does it look like? You get sued, so then what does the process look like? What would they have to deal with?
We may have talked about this in an earlier conversation, but I think it's helpful to understand at least the skeletal outline of a lawsuit. What happens is that a plaintiff, believing that they have a claim and generally having discussed it with counsel, although people can bring claims without a lawyer, drafts a complaint, or the lawyer drafts a complaint, and the complaint is filed either in a federal court or a state court. Generally, state courts have jurisdiction over Ohio law, and generally, federal courts have jurisdiction over federal claims. And if we're all in the same state, if the employee and employer is in the same state, the employee chooses, or the plaintiff chooses to bring a lawsuit under Ohio law, and for whatever reason doesn't bring it under federal law, they're gonna bring their lawsuit in state court. And it's interesting, plaintiffs, and particularly plaintiffs' counsel, put a lot of thought into whether it's better for a plaintiff in a discrimination case to be in state court or federal court. And there's some significant differences. For instance, in discrimination law, if a plaintiff brings a federal lawsuit under Title VII in federal court, they have an almost automatic right to attorney's fees if they prevail. That's an important distinction between federal law, Title VII, and Ohio discrimination law, 4112. If a plaintiff just brings a 4112 claim, generally, they won't get attorney's fees, even if they prove the underlying allegation of discrimination, unless a jury finds that they acted in a way that gives rise to punitive damages. At some level of outrage and misconduct that a jury says, you're going to have to answer in punitive damages at that point, then they can get attorney's fees. In federal court, you have to you have to prevail such that the jury is unanimous in its verdict. 8, you got to go 8 for 8 with the jurors. In state court, you've got to convince 6 of 8 jurors that you should prevail. So that's another important difference. There are more differences, and there's a close evaluation in terms of where a plaintiff wants to bring their lawsuit. But it's helpful to understand that. And oftentimes, when an employer is sued, and they're sued in either state court or federal court, their lawyer may say, well, wait a minute, first of all, this is in the wrong court.
Right.
It's something that comes up.
One of the things things that I look at, so I do some plaintiff's work, majority defense work, but some plaintiff's work. I think that it helps me understand what both sides are thinking. I think that if you get too entrenched on one side or the other, you start to look through rose-colored glasses a little bit. But one of the things that I look at is, if I brought this claim in state court, what county would I be in? So it's no secret in our practice that some counties are more employee or employer friendly. And if I can't, bring the claim in an employee friendly county, we'll do it in federal court. So that's another just kind of consideration from the mind of an attorney. Where is your business located? What type of court system are you in? That could come into play.
So what's a plaintiff trying to get? A plaintiff has accused you of discrimination, accused your business of discrimination, and what are they asking for as a result? Generally, in our legal system, money is a proxy for all things. We don't have the ability to restore most of the things that plaintiffs claim that they lost, and so we have to monetize their losses. In employment litigation, it's fairly simple. We want to know how much money you lost as a result of the employer's wrongful discrimination, assuming that the plaintiff prevails. So an employer will be liable for back pay. That means all of the money that the employee would have earned up to the date of trial. That's what we call back pay. And the employee is going to seek front pay. The plaintiff is going to seek front pay. And that gets a little trickier. That is essentially a jury finding, again, I'm assuming that we've had a trial, either the jury or the judge, determining, had it not been for this illegal misconduct, the illegal termination of the employee, fired because of some discriminatory illegal motive, how much would the employee have earned from the employer going forward? And there's some complexity in making that calculation. I can tell you it's a safe bet oftentimes that if the employee prevails, plaintiff prevails, they may get 2 to 4 years of front pay. There are times when you have somebody who's in their later years, say later professional years, say a 59-year-old plaintiff who says, well, it's going to be tough for me ever to work again. They may seek 7 to 10 years of front pay. There's no hard cap, but I can tell you it's unlikely you're going to get much more than 2, 3, 4 years. Punitive damages. Punitive damages can arise when a jury finds that your conduct, the employer's conduct, is simply outrageous and offensive to fundamental moral precepts, that it shocks the conscience and it is simply unacceptable conduct. And the reason that we impose punitive damages, should be obvious from the word punitive, is to punish the employer, to punish the defendant in such a way that others will take note. And that it's similar to one of the prongs of why we put people in jail and how long we keep them there. We want to, amongst other things, dissuade others from undertaking that conduct and impose penalty on the wrongdoer.
So let me jump in really quick. For punitive damages too, it's important to understand. So if you have an employee liability policy and insurance policy, they're not going to insure you for punitive. A lot of times it's just the compensatory damage part and attorney fees that's paid. That's actually pursuant to state policy where Ohio has decided, listen, if we're punishing somebody for punitive conduct, and the same is true for intentional conduct, insurance, being able to insure away this risk, it's not going to be very punishing. That's something else to consider.
Right, that's right. And along with these other remedies comes our most popular remedy, attorney's fees and costs. And sometimes that's where you can see a case that maybe has a $40,000 value turned into $150,000, $250,000, because once you've taken things through trial, you've run up very substantial fees. So risks always have to be calculated in terms of, could this give rise to me having to pay the plaintiff's lawyer? Reinstatement is something that a court can order. That's what we call an equitable remedy, where the judge requires that you undertake a certain act, which is to reinstate the plaintiff And then there are also emotional distress damages, which are not uncommon, or that is, they're often sought. And that is a plaintiff arguing that because I was wrongfully terminated, I suffered emotional damages, mental stress, lack of sleep, and a whole variety of maladies and illnesses that may arise from the trauma of having been improperly terminated. So that's kind of the spectrum of what we're looking at in very broad strokes as far as going to court. There's one topic that we talked about a little bit as we thought about having our conversation today, and that is the topic of reverse discrimination. And it comes up where a white male 28-year-old employee is terminated, and he believes that he was terminated because he's white. We call that reverse discrimination, and generally it's illegal. And in other words, if the employer were to say to this guy, listen, I've got too many white people, I'm going to let you go. Or makes clear that the reason I'm firing you with direct evidence, and we're going to talk about that in a minute, with direct evidence, and I'm firing you because of your color, yes, white people can avail themselves of the protections of Title VII, just like people of Asian heritage, just like people of African heritage, etc. However, and we're also going to talk about this, there's rarely direct evidence. Right. Usually we're talking about proving race discrimination with what we call indirect evidence. We'll get into that a little more in a moment. If the white guy is trying to prove discrimination with indirect evidence, he's got an extra burden to provide the court with evidence that this is the, quote, unusual employer who does or would impose this kind of discriminatory.
And kind of along those same lines is what we loosely refer to as associational race discrimination. So kind of the best example of this is you have a white employee who is married to a minority who doesn't work at the company. Their husband is black or from a different country, and the employer says, I don't like that. You're going to be fired for marrying that black person. Well, that's race discrimination, and how that shakes out in court is because the person is white and married to a black person, it's race discrimination based on the white person's race. Because if that white person was black, the employer presumably would not have a problem with them being married to a black person. So that's how those type of cases come up. And it's not infrequent that those issues do arise in the workplace. So Max was just talking a little bit about direct evidence versus circumstantial or indirect evidence. Kind of the holy grail of indirect evidence for us as attorneys is a case called McDonnell-Douglas, and it lays out what is called the prima facie case of race discrimination or any type of discrimination. So Max is going to talk just briefly about the type of case that a plaintiff would bring, an employee would bring if they had indirect evidence of race discrimination.
So prima facie, what we mean when we say that, I don't speak Latin, but prima facie tells the lawyer, you got to prove this before you can proceed. If you can't prove this, the employer is going to get summary judgment. That's really where the prima facie thing comes up, is that both sides take some discovery. We started to talk about the life of a lawsuit. After you file a complaint, you file an answer. Both sides are going to take what we call discovery. They're going to exchange some papers, and they're probably going to take some depositions. And at that point, when that process is concluded, it's likely that the employer is going to ask the judge to throw the case out. And when the employer does that, he's saying, listen, judge, we've got the evidence, we have the applicable law, this case cannot proceed to a jury. You should dismiss it now. In the framework, in a discrimination case, within which a judge makes that analysis and determines whether summary judgment is appropriate, is, as Maddie referenced, the McDonnell-Douglas, it's just a famous case, structure for prima facie demonstration of potential discrimination. So we ask some questions. Is the employee a member of a protected class? It's in the first and obvious question. I know there's sometimes that may be ambiguous, but let's assume that either they are of a racial heritage or national origin or whatever it is, that they're within the protected class. Then sometimes this is a contentious prong. Is the employee qualified for this job? The employer always wants to say, of course they're not. That's why I fired them. But it's not quite that simple, because, if the employee's been doing the job for a period of time, the analysis might be, yeah, they're qualified. We get that you think misconduct, got them fired, but yeah, it looks like they're qualified. Then you ask, did the employee suffer from an adverse job action? Usually that's as obvious as well. Yeah, they got terminated. But we get into a lot of scraps, and we counsel people very closely on these issues as to whether a particular job action is in fact adverse. Is it adverse if you transfer this individual from one department to another? Maybe, maybe not, often not.
Reassignment, I feel like, is one of the more contentious
Yeah,
issues with regard
absolutely.
to, is it adverse job action? Are they receiving similar pay, similar hours, reporting to the same supervisor? So all of those things we look at.
Or if the guy got hollered at because, of some kind of mishap in the workplace or mistake or whatever, but there's no write-up. Is that an adverse job action? Well, what we want to know is, did it materially affect the terms and conditions of his employment? Probably not. But at any rate, that's the next prong. Then this one also gets a little sticky. Was the employee replaced by a person outside the protected class? It's an important question. You say that, you plaintiff say that I fired you because of your heritage, but I hired someone of similar heritage. How does that make me? The question is always, did I fire you because of an illegal motive? If I fired you for race animus, why would I turn around and hire somebody who is of a similar heritage? That can give rise to summary judgment. And as you might guess, it's also a closely contested issue sometimes. And sometimes it's a non-issue because I didn't hire anybody. That still doesn't get me off the hook for discrimination if, especially, the plaintiff can point to other people within your organization who are legitimately described as comparators. That gets a little rich with argument too, because, did they work for the same supervisor? Did they essentially do the same kind of job? Were they in the same shop? There's a whole kind of breadth of questions that we ask as to whether an individual is in fact a comparator. And one of the heavier questions is, did the individual engage in similar misconduct such that they're a legitimate comparator? But at any rate, the plaintiff may also point to a comparator. This guy also, goofed up in the identical fashion, and rather than a formal write-up which led to suspension and termination, he got a wink and a nod, and here he is still there today. And then if the plaintiff can kind of demonstrate these elements that we described, then the court turns around, literally, figuratively, and the employer has the opportunity to explain, okay, judge, all that may be true. Maybe, but here are my legitimate business reasons for why I undertook the action that's at issue here. And most typically, it's the what the misconduct, the purported misconduct, the purported performance deficiencies, whatever, the nature of those matters and the impact on the business. And the court may say, yeah, you were clearly motivated by this accountant's failure to properly, enter into your books this data, which could have given rise to catastrophic miscalculations on your part. Or it remains open, and maybe you go on to a jury. But before we go anywhere, the employee, the plaintiff, has the opportunity to say, okay, judge, we heard the explanation and we heard the alleged, legitimate business reasons, but now I have the opportunity to demonstrate that those are pretextual. Those are a pretext for discrimination. He's saying that, and on its face, it sounds legitimate, but the real reason that he undertook what he did is discriminatory animus. We used the word earlier, consistency. One of the easiest ways for a plaintiff to demonstrate pretext is inconsistency. Inconsistency in treatment of employees, or here's the killer, inconsistency in what you told me was the reason I got fired.
Yep.
The day you fired me, you told me you hated to have to do it, but you just had to let me go because you just can't afford to keep the job staffed the way you've got it.
One of the best examples, sorry, I'll just jump in quickly. One of the best examples of that has come along in my practice is a company told and I was on plaintiff's side for this one. Company told an employee that they were terminating her position, period. They were getting rid of the position, and then turned around and advertised for that position on Indeed. That right there is a red alarm for pretext.
That happens a lot, and people sometimes try to artfully reconfigure a position so that supposedly I'm not replacing you, but anybody with a lick of common sense can look at it and say yes. And I use the word common sense, and that is really what a lawyer ought to bring to a counseling opportunity with respect to HR related matters. Maddie and I do a lot of stuff business related that doesn't have anything to do with Title VII or discrimination, whatever. But when we're talking about administering a workplace, use your common sense and take a real look at things as opposed to a look, that maybe those around you are urging you to take.
Another really important thing to mention in pretext is temporal proximity. So a lot of what you'll see argued in that regard is I reported race discrimination, and this is more in the retaliation issue. I reported race discrimination, and then they fired me that same day. So how quickly in time was the adverse job action taken to a report or an issue of race discrimination? That becomes very important. Now Max is going to talk a little bit about kind of the other side that an employee can argue, and that's if they have direct evidence of discrimination.
Well, this is just the old-fashioned way of proving something happened. Yep. I mean, I can just show you that, the guy said that he doesn't like my religion, and the next day I was fired because I told him I needed my religious holiday off. You think of any number of other examples of that, and I can tell you it's pretty rare.
Yeah.
We don't run into a lot of employers that said, you know what, I just can't have someone of the Buddhist faith on my job.
Right.
It just doesn't happen very often. That doesn't mean that people don't bring discriminatory intent determinations or job actions. It just means that most people kind of understand that that's not necessarily the way to present it to the world. But more often than you would think, it does happen.
Yeah.
Not as much, well, the most frequent, in my view, that we see is in the age context.
Yeah.
You get a lot of direct comments like, I know you have to be getting ready to retire.
Right.
Or you really should be getting ready to retire. Mm-hmm. Or you probably can't handle this new software application we're bringing in because I just know that at your age that's a little tough. Mm-hmm. So we do see a fair amount. It's more often in age, but it can happen elsewhere. It's as we've set forth here, direct evidence is that evidence which, if I believe it, kind of establishes or requires the conclusion that unlawful discrimination motivated what I did. And these are decent examples, the use of racial epithets. Okay. Believe it or not, it's a relatively hot topic in the law.
Okay, we're on. Yeah, Marcia, do we have a question?
Yeah, actually, I'm the one with the question. So one of a company that I had called on, their admin person was older. She was, I think, over 75 or around 75. And the people who took over the company didn't really think that she would be able to implement the new ERP system and do the tasks at hand. And she even had trouble at putting attachments on emails and different things. So I'm asking, are there some cases where it is a legitimate thing, say, you know what, it just might be time to retire? Or are you always faced with the reality of it being a discrimination?
Well, with regard to saying it's time to retire, I would refrain from using that type of language, you know, because that on its face is saying you're too old to work here. Now, it is a legitimate concern if they're having performance issues, if they cannot perform the duties of the job. That goes to whether or not they're qualified. And an employer's defense would be, no, we did not terminate you because of your age. We terminated you because we wrote you up because you could not attach emails to, you couldn't put attachments on emails. You demonstrated this, and this time. You couldn't fulfill that requirement of the job, and it's a termination based on performance, not because she can't perform because of her age. So I think it's important to focus on performance deficiencies that are true performance deficiencies rather than those deficiencies are tied to a person's age.
But Marcia asked a tougher question, or at least as I heard it. You're kind of asking, all right, I am prospectively going into a new, whatever it is, a software environment that I know darn well, you know, my longtime assistant here can't handle, because she's demonstrated she can't handle other fundamental kind of technical operations. And so I'm pretty sure she can't handle this one. I'll tell you, that is fraught with risk.
Yeah.
And it's a great question. And I think I would probably counsel someone through developing some objective standard that establishes whether they can or they cannot function under whatever this new regimen is. And that would perhaps even involve, you know, some testing or some, you know, introductory type of analysis in terms of ability to get it. But to just say, listen, at 75 years old, let's face it, you're not going to be able to handle what we've got coming downstream, I think is not a well-counseled position. Fancy way for saying your lawyer shouldn't let you do it.
Correct. I agree.
Thank you.
So Max talked a little bit about direct evidence and the prima facie case of circumstantial evidence of race discrimination. But just like how we've discussed a hostile work environment scenario with regard to sexual harassment or disability discrimination in our previous presentations, that same hostile work environment case can be brought with regard to racial and national origin issues. So when is harassment based on race, color, or national origin so severe and pervasive that it alters an employee's terms and conditions of employment? So it's the same type of analysis no matter what type of discrimination you're looking at, but a lot of times if there's, let's say, racial epithets being thrown around or jokes about somebody's accent, that can create a hostile work environment if it's prolonged and so severe that, you know, this person can't function in their job. For employers, it's important to understand kind of the standard that we'll be looking at to judge whether or not this conduct was so bad that it impacted a person's work environment. And this is kind of a little bit legal, but it's important to understand that it has to be objectively hostile. So a reasonable person standard is utilized. Would a reasonable person have been offended? Would a reasonable person not have been able to function in their job? And it also has to be subjectively hostile. The employee actually found it to be hostile when they were in their working environment. And retaliation is another usual companion claim that can be brought with a hostile work environment claim or just a claim of discrimination. And this is when an employee reports or takes some sort of protected action So they would report internally or maybe file a charge with the EEOC, or file a lawsuit. Max and I were just involved in a case where the plaintiff was still employed at the employer that she was suing, and issues of retaliation came up throughout the lawsuit. Workplace retaliation based on any reports of race discrimination or national origin can be companion claims with any type of hostile work environment or just regular race discrimination.
To me, two important questions, if not determining questions, that arise. Did this person really undertake what we call protected activity?
Correct.
You know, that is, I don't think you should discriminate against people because of their race, or was it just some shapeless complaint and, you know, whatever? That's A. Was it protected activity? And then B, is it possible to really attach, or what we would say, is there a causative chain between the adverse action and the protected activity? Maddie raised earlier the issue of what we call temporal proximity, which is just how close in time did it happen. If it happened a year after the supposed protected activity, it's unlikely that somebody's going to be able to establish discrimination or retaliation. If it happened 10 minutes later, obviously different story.
So we wanted to spend just a few minutes, I know we're coming up on time here, but just discussing some of the things that we've seen that are examples in our practice of race or national origin discrimination. So recently, I was involved in a matter where a African-American employee applied for a promotional position within a company and was told by the interviewer that she was the wrong face for the job. They then hired a Caucasian female for the position. This did not, we settled the case, but it did not reach the summary judgment stage. But if it had, I was plaintiff's counsel for this case as well. I would have argued that this is direct evidence of race discrimination. If she's the wrong face for the job as an African-American, apparently the company feels that a white face is the more appropriate face for the position. This was an outside-facing position. It was a community-based position. So, you know, comments like this are where you can run into some significant issues with direct evidence of race discrimination. And a lot of times, unconscious bias can play a role and create a race or national origin discrimination issue where one was not intended. And I think Max has some good examples of that in his practice.
Well, you just, you know, as you counsel employers, and also sometimes as we see it in litigation, one thing that oftentimes a plaintiff believes, and sometimes a well-counseled client will see, is that maybe you're too quick to, or you're quicker to make determinations of success or failure based on preconceived notions of grounded in some immutable characteristic. You maybe assume a lower level of competency, for instance, with people of a certain background. And I'm not trying to use code words, people with, you know, whose immutable characteristics give rise to your view that they're maybe not as sharp. And so where you might give a Caucasian guy a number of opportunities to kind of rectify some performance deficiency, maybe the first time you see it from an African-American guy, you conclude he's just not the guy for the job. That's a pretty good example of an unconscious bias. You don't think to yourself, I don't want people of a certain race or a certain ethnicity on my property, but in fact, you brought those assumptions to your decision making. And that's why when an employer comes to his lawyer or her lawyer and asks questions about an upcoming job action, the lawyer ought to push back a little bit and ask about comparable situations with other employees. Ask about a consistent application of this evaluation criteria, and make sure when you test yourself, when you do a little pressure testing, I used to work for a plumber when I was a kid, you do a little pressure testing. Do we see leaks? let's ask. Also, just generally, there are certain tasks that people may think that some employees are more prone to succeed at: negotiating, writing, calculating, etc. Those are examples of kind of an unconscious bias, that an employer may bring and may be called to answer for.
Marcia's question was a great example of unconscious bias.
Exactly.
Older people are not good at technology. That is one of the most unconscious bias that's just not generally true in the workplace, especially in the workplace. Maybe they can't work their Apple phone as well as their, young grandkids, but when it comes to professionalism and them doing their job, that's one of the #1 unconscious biases that we see, I think. And I think also we're running out of time here, but I do just want to say, similar to how there is a heightened focus on culture and what is appropriate in the workplace with regard to sexual harassment, the same is true for race discrimination and national origin discrimination. There's a shift in culture. There's no room for shop talk anymore. And I know that a lot of you on the call are manufacturing employers. So you may have some of this. It's really important to nip these issues when they come up, because if you allow them to persist, you're going to have a culture of discrimination. You're going to have a culture that says these small comments are okay here. And those small comments can add up to a hostile work environment claim.
So I'm going to push back a little bit and say there's always going to be room for jokes, for shop talk, because there's always going to be shop talk, realistically. What can you do to preclude that from, blowing up into a workplace that's undermined by real discrimination and or real discrimination-based lawsuits? I mean, we've talked about a lot of this, but in terms of reducing the risk of how this kind of stuff can wreck your a business and or drag you into lawsuits, we thought about creating a diverse culture. Tangibly, create a reporting process. It's just like, I think we had the sex harassment, conversation a few weeks ago. If you have a reporting process in place, that's huge, because then people would, hopefully, if it's rational and it's fair and it's real, people will feel that they have the opportunity to come and explain or express, a sense that I think I'm being mistreated, and I think it's because of my background. Employee handbooks are important and should set out a lot of fundamental precepts. One of the first and foremost being, this is not a business that will tolerate discrimination. And Maddie, we might be getting pushed. I don't know where we are time.
I think we are running a little bit up on time. But a lot of this reduction in risk is what we've been kind of preaching this whole time. Have consistent policies, enforce them consistently, give your folks training, and have policies in place that tell your employees, we are a company that does not allow discrimination here, and this is what you can do if you feel that these policies are being violated. And to the extent that you have any questions, those reduction in risk strategies are something that Max and I counsel employers on every single day. So if you have any questions about any of these strategies, feel free to reach out to us. Our contact information is on the screen. And thank you for listening to us, and we hope that we've provided some value for your workplace.
Thank you.
Thank you guys so much. Marcia had to step away because she has landscapers blowing right behind her. So she asked me to step in and wrap this up. So we just want to thank everybody for being on the call today. Sorry, Max and Maddie, all three presentations were great. Thank you so much for your time and for your generosity with the service you're providing to our members. We encourage all of our... Absolutely. We encourage all of our participants to share your thoughts on topics you'd like to have us cover in future webinars, and we'll do our best to address them for you. As Marcia mentioned, this webinar is being recorded and an archive version will be on our YouTube channel. You'll get a message from me later today with the links to all three of these webinars. Thanks again and have a great day.